Because 370 talked of three things. One, you need consultation, concurrence, and recommendation. Three words are used. This is one side. Two, who are the institutions involved? You have the President of India, you have the government of the state, and Constituent Assembly. Three. All the provisions will also, which only three authorities are involved. But this government of the state is further requiring, in terms of the explanation, that it means a person who is recognized President of India, who has aid and advice of the Council of Ministers. I lay emphasis on this, that this is a mandatory, indispensable part of Article 370 that you have to have in all situations. 356 or no 356, you need to have aid and advice of the Council of Ministers. You cannot make any CO without the consultation, without the concurrence of the Council of Ministers. I am laying emphasis on that part. Yes, sometime back there have been, out of 54 constitutional application orders, there were about 6 of them which were passed when state was under governor's rule or president's rule. But our stand on that, they were questioned. Before this court, I am told that some writ petition is pending. They were questioned, Jammu and Kashmir High Court, the things remain. People did question them. Of course, they did not reach the logical conclusions. But at the same time, I must say that if they are unconstitutional, they can be questioned at any point of time. Law of laches does not apply to when the statute is unconstitutional or any action is unconstitutional. So even today, when we see this constitutional application of 2019, and we are questioning that, so we are free to question that on the basis that it was done without Council of Ministers being in place. This is the crux of our argument in this case. That's why I said earlier that let us go to the fundamentals. That the fundamentals in this case are this. Number one, that for this kind of change, which was made, it is not relatable instrument of accession, therefore consultation was not required. Concurrence was required. It is a mandatory requirement of 370, number one. Number two, the definition of the government given only for purposes of 370. I must make little digression here. We have government of the state under the Constitution of Jammu and Kashmir. And we have a far better provision there. That is section 35, which says, sir, that the governor will act only, the word used is only, on the advice of the Council of Ministers, which was not, you'll also will not find it in the Constitution of India at all. That way, how better our Constitution is. What you'll also ruled by judicial decision, that the advice of the Council of Ministers is binding on the President. Our Constitution already way back in 1957 contained this provision, that it should only act on the aid and advice of the Council of Ministers. Now, what do? So it means that the governor could not act without aid and advice of Council of Ministers in our Constitution. And here in this case, the governor acts. Fundamentally, apart from the other jurisprudential basis of the submission which have been made very at a different level, fundamentally, could they do that? Could the governor at that point of time do that? Now see more additional reasons. At that point of time, I was under 356 President's rule. What is its effect? Leave the 356, or what does it contain? 357. My legislature is not my own, it is taken over by Parliament. My governor is not my own, his powers are taken over by the President. My government of the state is not my own, it is taken over by the President. All this is taken over by the President. Then in terms of 370, who gives concurrence? And who accepts that concurrence? We have a judgment of this court saying that when 356 is there, the powers are taken over by the President. How does he act? The President will act on the basis of the advice of the Council of Ministers, and this Council of Ministers is like the cabinet of the state government. If this be the correct legal position, it all means all is rolled into one, that is President of India. So it violates on the face of it the text, the requirement of Article 370. Forget for the time being, of course, without prejudice to what brilliant arguments have already been made, without prejudice to them. How could the President of India, when 356 is in operation, act on the advice, on the recommendation made by Governor of Jammu and Kashmir, which governor had the status only, some, your lordship, some decision describing as an agent of the president during 356, or some judgment to say that he acts as the president. In either of the situation, he is not the governor who has aid and advice. So for purpose of 370 and for purpose of other functions of the government, I respectfully submit there is a difference between the two. Specifically for 370, you need Council of Ministers. I'm not able to conceive of a situation where there cannot be Council of Ministers. That's the third thing. And the fourth thing, which is very important, is this, that you have applied 367 and modified it and applied it. Now, for the consideration of my Lord Justice Khanna in particular, my lords have been observing. What do you think of 3.1d, where you apply constitutional provision with modifications and exceptions? I'm saying something else. You first applied 367 by virtue of 3.1d. You applied that to which provision? You applied that to subclause 3 of 370. Subclause 3 says, notwithstanding anything contained here and above. The question which immediately falls for consideration is, if you have carried out a modification in terms of 3.1d, but applied that modification to subclause 3, when the 3 says, notwithstanding anything contained here and above, isn't that 367 modification excluded from application to subclause 3 of 370? I'll consider this aspect of the matter. And it says, notwithstanding anything above would mean also any constitutional application order issued under 3.1d will also not apply when you want to act under subclause 3 of 370. So therefore, on that basis also it has to be faulted. So therefore, I'm submitting is going by the basic premise, the basic principles, that this action of 272, it does two things. Best part, then the last thing which I want to submit to Lordship consideration is one more thing. This power of concurrence. I say, for your Lordship's consideration once again, in 1957, we adopted our own constitution. Prior to that, we had Constituent Assembly. As rightly said, Constituent Assembly can do, undo things because it is not subject to any fetter. There is no control on a Constitutional Assembly because it's free to evolve and deal with its affairs. But after the Constitution was adopted on 17 November 1956, I'm submitting this. The state government comes into existence under the Constitution of Jammu and Kashmir. But at the same time, the state government is required to give its concurrence or consent under 370. I say my constitution, Jammu and Kashmir constitution, is in the nature of a limitation on the power to give concurrence after 1957. Meaning thereby, even if there was Council of Ministers in place as on today, they also could not give any concurrence because it is subject to the limitations of the Constitution of Jammu and Kashmir. Now, what are those limitations? On the prima facie, I will show. If you will have a look at 272. The first part says, the Constitution of India as amended from time to time shall apply, subject to the modification as follows, that is 367. Means the entire Constitution is made applicable on the so-called invalid, unconstitutional concurrence of the governor. When you do that, you are contradicting Constitution of the state. And when you are contradicting Constitution of the state, there is a limitation in your power of giving concurrence under the Constitution of the state. Meaning thereby further that our Constitution had to stay. It had to permanently stay because the state government no longer could give its concurrence in contravention of the provisions of the Constitution of the state. That limitation will have to be read into this power of concurrence after 57. Of course, there will be provisions which don't come into conflict. For example, take the High Court. Somebody cites the example of the High Court. Now it is established under my Constitution. When you say somebody gives concurrence, the Article 215 of the Constitution of India will apply. It comes directly to conflict with my Constitution. The question is not that that is superior, I am inferior. No, the question is, did I have the power to give the concurrence for the application of 215 or any other provision of the Constitution of India? My submitted lordship says I am controlled in my concurrences now, I'm controlled in my consultation is something different that relates to instrument of accession. But in respect of application of these constitutional application order, I'm controlled today by the Constitution of Jammu and Kashmir. So therefore, on that second ground, also, I say that this 272 as well as 273 both constitutionally absolutely invalid. Now, my lords, observe that, okay, you are still in history, let us progress further. Isn't this COs issued 54 in number from time to time? It was not a step in right direction. I put it to myself. It was getting closer and closer. What made you to do it on 5th August? It is not still forthcoming. And there is something more to it also. You also may recall, I said, when this concurrence is given by the government, this Governor Jammu and Kashmir, as stated in the text of 272 order. When was that concurrence given? Who gave that concurrence? What was the nature of concurrence? No material that is concealed from this court. No material is produced before the court. It is not in their affidavits. Despite having been stated in the petition that, look here, we want to know who gave this concurrence. What is the date of that concurrence? Who signed that concurrence? Was it done 1 day before? Was it done 10 years before? Who gave that concurrence? We are entitled to know it. This court is entitled to know it. There is no material on that basis. So therefore, that apart. But further than somebody says that we have given the concurrence, it doesn't look legitimate. It doesn't look sustainable. It looks all against the Constitution itself. Then lastly, I would like to submit, many statements were made here. Insofar as the development is concerned, I have only one thing to say to our learned friend, Solicitor General of India. They say self-governance is better than good governance. That's all I can tell him. Give us our self-governance back. That's number one. Number two, somebody also said it here, it's very important. Nation has to grow. We can't waste our time. We want to have a unified nation. Of course, very noble thought, very good thought. But then for that, you have to win over the hearts of the people. You cannot form a nation by force, by compulsion. Win the hearts of the people. If your lordship decides this matter in favor of the petitioners, your lordship will be going a long way in winning over the hearts of the people of Jammu and Kashmir. That's all I would thank.
Thank you, Mr. Shah.